Thank you, Nate. Welcome back, everyone. We're discussing Bill H 642, an act relating to youthful offender proceedings. And next, we're going to be hearing from Judge Davenport, Counsel for Equitable Youth Justice.
Right. Thank you very much. And I'm once again happy to be here. I think this is the first time this session. I was here last year, I guess. So this year, I did file a memo on the original draft of the bill. I have it in paper copy if anybody wants it. I know some of you are very up with the electronic stuff, but I'm not as good at that. And the paper route, I love the paper route. I'm joined today. The Council for Equitable Youth Justice, as some of you may recall, is the state advisory group that we do a number of things, including grants with the federal juvenile justice money. We make recommendations to DCF with respect to how those the juvenile justice money should be spent. We send out. We try to look for gaps in the system, in the youth justice system. We send out requests for proposals to try to find services to fill gaps. We do follow legislation involving the juvenile justice system. I'm joined today, she is on, by Judge Hayes. Judge Hayes is also a retired Superior Court judge who recently joined the council. She is helpful for me because she has far more immediate experience. I, as you know, retired in 2015 and do not regularly sit on the Family Rules Committee, but I don't regularly sit in the family division or in the Superior Court. Judge Hayes has much more recent experience. I will be cycling off the council at the end of this month, and she has cycled on, and so you may see her more frequently in the future. So just to, I know that your time is limited, and to
whatever time you need.
Thank you. So before I comment on the specific provisions in the new draft, I just want to say this is an incredibly successful program. We should be all patting ourselves on the back for a really successful program. You all very astutely asked the CRG to give you data on this program, and data specifically related to recidivism. Now, sadly, with criminal justice programs, recidivism, and that is whether or not an offender reoffends within a 1, 2, or 3 year period. I know you all know about this because you've been looking at recidivism bills and definitions of recidivism. There are many ways that we could track how good a program, a juvenile justice program is. We could look at education, we could look at housing, we could look at employment. We don't have easy ways to do that. But the one way we have is to look at recidivism rates. Now, just to give you a context, in this group, this age group, which can range from 14, although that would be rare, it would be more likely 16 or 17 to 22, you're dealing with the cohort, an adolescent cohort that has a high recidivism rate. When the council funded a study, it was 4 or 5 years ago, to look at the recidivism rate of 18 and 19-year-olds who had gone through the criminal division. And we did not, we specifically kept out of that study any Big 12 offenses. So none of the big serious violent offenses. We were looking for a benchmark to compare what happens to them when they go through the family division. And that's a study that's currently in progress. But when we looked at the recidivism rate for those 18 and 19-year-olds that went through the criminal division, there was a 3-year recidivism rate was close to 50%. Recidivism rate that you got for the 95 in YO individuals that went through the YO program during a 2-year period, I think was from 2021 to 23 or 22 to 24, the 2-year window. There were 95 individuals, and the criminal research group found that the 1-year recidivism rate was 10%. The 2-year recidivism rate was 16%. I don't know of any other programs involving offenders that have a recidivism rate that is that low. And that's why I'm saying this is an incredibly successful program. So not that it isn't important to look at various aspects of that program to tweak them if there are problems, but just keep in mind that this program as it exists today is incredibly successful, at least based on data. Yes, are there kids that get in this program who mess up? Yes, there are. But are there kids in the adult programs that mess up? Yes, there are. It is the hallmark of adolescent kids that one time or another, they're going to mess up, and sometimes very badly and sometimes repetitively. So I just want to start with that because it is, I think it's something that gets lost sometimes. So looking at, and I don't know, Kate, do you have anything to add? Judge Hayes, sorry.
No, that was great. Absolutely right. Thank you.
Judge Hayes had. So looking at the First Amendment, which adds to the criteria whether or not the youth has acknowledged that harm was caused by the youth's alleged conduct. We had 2 concerns about this. I'm not a restorative justice professional, and maybe one should hear from restorative justice professionals, but my understanding is that acknowledgement of the harm caused by behavior is an outcome of restorative justice as opposed to what would get you into the restorative justice program to start with. So I worry a little bit that this is putting the cart before the horse, although it is one out of a large number of criteria. The other is what the additional language that was added to shield the use, if the youth did acknowledge the harm in a hearing on YO consideration, to shield the youth from having impermissibly having that acknowledgement, because the youth is subsequently going to go to merits, right, in the family division. And so this provided that the information related to the offense shall not be used against the youth is designed to try to allow the youth to say that he acknowledged harm without incriminating himself or herself. I just would remind the committee that the judge that's going to be making the decision in most cases, not all, but most cases, the judge that's going to be making the decision about YO eligibility is the same judge that's going to be hearing the case on its merits. It's not a jury, it's a single judge. And judges are really good at compartmentalizing, but that's a heavy lift in terms of compartmentalizing. So those are 2 concerns about adding that language. The next is the extension of jurisdiction on page 5. I think we have no comment on that. We understand what the purpose is. Maybe it should have an endpoint, but we don't, so that we're not talking about having the youth under jurisdiction indefinitely. And maybe it should have a requirement in terms of how quickly, in those particular cases, revocation hearings should be scheduled, because you want to get it scheduled quickly before, but we don't have a problem given those parameters with the extension. On page 6, the two added criteria, which are for this goes to revocation. Sorry, on the revocation hearing, adding the criteria from subdivision 5284A2. Maybe the language should be on B, whether the youth continues to be amenable to treatment. You've already found that the youth is amenable to treatment. That was your initial finding when you found them to be eligible for this program. So rather than, I guess the language that Eric had is remains, or continues to be, maybe it's the same thing, but I think that's the concept there. And then there are, whether there are sufficient services in the juvenile court system. I mean, things could have changed so that the services that were looked at during the initial consideration, now the youth has shown some behaviors that require additional services, and are those services available? But so again, whether sufficient services continue to be available in the juvenile court system. So really the most problematic, I think, is this failure to appear section without good cause. And there are many reasons why a youth in this age bracket, especially the youth that are 18 and over, might fail to appear. And one of the most obvious ones is homelessness and the inability to get mail. The inability, not having a phone, that not being able to be contacted in some kind of way about a court hearing. But again, I think your good cause language covers that. And I think that the language in the second provision, issuing the court summons or a judicial summons, I would add a reference to 33 VSA 52061, which is the reference to the juvenile the provision that Eric mentioned that has to do that is in the subchapter on juvenile probation. And that does allow for the judicial summons. Does it pose a problem to have kids who go out of state? Yes, but I would really steer clear from giving the family division the tools that are in the criminal division's toolbox, i.e. an arrest warrant. Family division currently does not issue arrest warrants. And we shouldn't be issuing arrest warrants, I think, in this situation. So if you have a youth who is summoned using a judicial summons, maybe at that point they fail to appear. Maybe at that point you revoke, send it to the criminal division. Let the criminal division issue the arrest warrant. Let the criminal division detain, but don't do it while they're still in the family division. The family division has a overall rehabilitative purpose, and using those kinds of tools are generally thought of to be inconsistent with that.
So could it be that we combine these two, that essentially the first step is the second choice, the summons and the issuing order for apprehension? And then if that doesn't work,
That fails.
that second step.
I think that would be better than having the family division issue arrest warrants. I just think then you begin to blur the lines between the two courts in a way that feels very uncomfortable as someone who's tried to figure out family division.
So is the order for the juvenile's apprehension and arrest warrant, or is that's different, isn't it?
Well, it's the order for in 5206 talks about the court may summon the juvenile to appear before it. That's a judicial summons.
Right.
And you can say a judicial summons during court hours. So they're brought to the court during court hours. But it's different from arrest warrant. It is different from putting a kid in handcuffs.
Right.
Yeah.
But let me just make sure that, again, the juvenile's apprehension component, that line under 33, BSA 5206, that the way that language is, or are you saying that it shouldn't have that?
In order for the use apprehension for purposes, I would just say consistent with section 5206 subsection
The
1.
whole thing is.
Yeah, I would just cross-reference that so it's clear that you're using the same kind of juvenile probation proceedings for getting youth to court in the YO, when the YO is in the family division.
Yeah, but Chair, I think were out when it came up that there were, about the arrest piece, that there was a recommendation to make it clear that, or suggest that you could arrest at 18. So that was a suggestion to change it. So I think that's why it's coming up. And so just to go down that road a little bit is, and what I'm hearing you say is it's not a family court tool, like that would make things messy. And instead, your preference would be that it just revocate, just go to criminal court rather than having that tool there.
Right.
And I'm trying to balance it because I'm not saying I want to go there, but like, if you put it into criminal court, now that opens everything up. But is that still less messy than giving a criminal court tool in family court? You know what I mean? I see it as, okay, not great, but I would rather them not be in criminal court, but in family court with a not great tool.
Not to confuse things, there is one way that the family court does issue arrest warrants, but that is only in the criminal contempt. So holding somebody in criminal contempt for failure to appear in a child support case, for example, that would then trigger the arrest warrant because it's associated with a criminal contempt. I should make that.
Okay, there is an
clear.
instance.
So there is an instance. I think when the youth is failing to appear, you could give the adult court away once they've issued the arrest warrant. Once they've got the juvenile comes in, the juvenile has a perfectly good reason why they didn't respond to the judicial summons. You could give the adult court the ability to send it back, but I just feel more comfortable.
If it goes to the adult, it's now everything's public and out there, right? So you would have opened up the gates.
Yeah, you do it.
Which is the piece that I want to do. But I hear the piece, the tension.
Yes.
What about if we could do something that would allow for either or based upon exigency or where the child may be or the person might be if they're over a state line? A summons isn't really going to be helpful over a state line that don't might want to go, or the behavior that's occurring. One might be appropriate versus the other.
You mean one, i.e.
Issue a summons first if it's appropriate in the situation, if not.
And then go to the arrest warrant without a finding of contempt? Or you could make a finding of contempt. I don't know if you could do the contempt. I just don't want it to take longer than it needs to.
Well, they can leave it to criminal court.
Right. I don't know. I think there's some different, there's some other parameters. I don't know, Judge Hayes, do you have a thought on this?
There is an interstate compact on juveniles that we're part of, and that I think does enable, it's not as efficient or as clean as NCIC. I know Lindy expressed concerns that whatever orders the family court issues are not as effective as arrest warrants because they can't be entered into the national criminal database. But there is a juvenile database that involves all of the other states that we regularly see folks living in and coming to and going to.
Right.
I think all of the states are members of it, and that would enable us to reach out to the equivalent DCF in whatever state we know the person is in and ask them to pick them up and work with us to get them brought back.
It would certainly work as long as they're under 18. If they're over 18 and they don't qualify as a juvenile in those other states, then you might have a might still
Then
be.
the other thing that I thought of was, I wonder if we could, rather than simply saying revoke youthful offender, if we could suggest that it be temporarily suspended until they could be brought back to court, until they appeared in court. And an arrest warrant could then be issued in the criminal division. And then they, as soon as they popped into court, they would come right back.
Or not.
Or
Depending.
not. Yeah,
Yeah.
if they didn't, then yeah. I think temporary suspension for a failure to appear without cause, and frankly, I think most judges are gonna, if there is any reasonable cause, they're gonna not treat this as warranting even a temporary suspension. But if
Is there
there's no
such a,
cause,
is there such a
Makes
thing as a
sense.
temporary suspension anywhere else with youthful offender at this point?
no, but you could create one, I would
We get
think.
to do that, yeah, it's true.
I'm not sure.
Tells us
I'm not sure. It's
law.
they just came to me as you were all as I was listening to the testimony this morning. Don't know what the council's position on it would be. I'm just speaking for myself. So it seemed to me that might be a solution if you really want to include the first clause.
There aren't that many revocations. When I looked at the data from the criminal research group, and really that data that you all got from the criminal research group, which really was so enlightening about how well this program is working. It seems to me that a more serious effort to really look at these 95 kids and what did they do and how, what were their outcomes and, and things like what were the revocations, what were they about? And the criminal research group's able to do that. I mean, they have remarkable, they use court data regularly and they are remarkably good at it.
So a possibility could be still using the summons, the apprehension consistent with 50206, and some language along the lines of, well, this isn't the language Eric will use, but if it doesn't work, then you can do the temporary suspension.
They failed to
I mean, I
appear.
think we'll need to hear from some other
Yeah.
witnesses on the concept of a temporary suspension versus a revocation. So,
Mr. Chair,
yeah, go ahead, Coach.
Judge Hayes, that was a great idea. And, thinking from a practical perspective, having dealt with that population, directly in a number of different areas,
Thanks.
it adds to the toolkit, of practitioners, especially in the field, because you never know what tool is going to be the leverage one that triggers the response we're looking for. So having something, that isn't, let's say a sledgehammer, but it's more like a rubber hammer.
You could also do, just thinking about that, Coach, you could also include warning language on the notice and the judicial summons saying, here are some consequences. Your case may be going over to the criminal division and you may end up being sentenced. I mean, I think we could give more alerts about, I don't know whether those alerts work, but there are a number of them in statute that say the notice shall include and
And that gets to Chairman Lalonde's, premise as well. So hopefully, if we get continued support from other witnesses, that's a good direction. That might not be a bad way to go, Chair.
All right. Did you have more questions?
Did Chase anything else?
well, I did have on the acknowledgement of harm piece. I would just want to double down on Judge Davenport's position on that. I think it's at this stage, they've been charged. They have not been found to have done anything. The only finding that's been made is that there's probable cause to believe they may have committed an offense. So asking them to acknowledge harm, this is so inconsistent with Fifth Amendment rights. I just really am troubled by it. And I think that any defense attorney, even with this language in the statute, will still tell them, don't do it. Don't acknowledge that anything happened here. We want to preserve all of the options for your defense because there's been no trial. There's been no hearing. There's been no finding that they did anything.
So just for, I'm sorry, for a further opinion, the reason why this is here is there's been recommendations or suggestions to go back to the guilty plea, the conditional guilty plea. And the idea here was something that was not that, but
I think you got to pick. That would be my thought, is that procedurally.
Okay, all right.
That would be my preference.
The other thing I would add to what Judge Hayes said is that from the kid's perspective, from the youth's perspective, I pity the defense lawyer who has to try to explain to them, you can say this, but then we're going to have a hearing on whether you did it or not. And the judge can't pay, the judge who just heard this can't take that into, and the youth just says, what is this system? It's just, I don't know. I think more and more these days about what the system looks like from the perspective of the people who go through it. And we can make all these machinations, but it gets harder and harder to explain if you are trying to represent them.
Perhaps that's a good segue to hear from the Defender General's office.
Yeah.
Thank you very
much.
Thank
Thanks.
you very much, Judge Hayes and Judge Davenport. Valerio, if you could join us. Thank you for being here.
Yeah, I am. I don't know about you. I'm Matt Valerio. I'm the Defender General. To be clear, as I said the first time I came through, we didn't support the original bill in any way, and that it was looking for problems that didn't exist. This is apparently this came into my email sometime between 9:30 and 10 o'clock last night. I did have a chance to look at it this morning while I was in another meeting. And, one of the things I don't do that I think other folks do is sort of negotiate ground away on these cases or on these bills and proposals. Because whenever I do that, I'm not representing one client, I'm representing thousands of clients. And if I agree to give away a right or to change a procedure that's a compromise against something that's to the benefit of that client, it's not one client, it's 2,000. And what I see here, in fact, is, I hate to use like caricature, but this is putting lipstick on a pig. I didn't like it to begin with. I don't like it now. And this is trying to accommodate some of the concerns that I brought up to begin with, but it doesn't do it and creates other issues. So, my original feeling about this, and I guess I'll just tell you, is that I don't support any of it, and I'll deal with it in the Senate. And it's perfectly fine. Happy to do that. If you have any specific questions, I'll be happy to try to answer them or not. But what I see now is we have, notwithstanding any individual anecdote that might have happened 3 years ago, we have a system based on data that we've received that is working well. Doesn't mean it didn't work badly in one case or two cases, but we had a system before where we had 20 people a year doing youthful offender, and now we have hundreds of youths doing youthful offender. And the people who are taking advantage of it, for the most part, are doing very well in the program. And so while I think there are procedural things that could be fixed in the regarding the youthful offender process, this does none of that, and goes after other things that basically seek to unravel the very basis that youthful offender was designed to deal with. And one of the big things is we wanted youth to get involved with it. As I think I heard the end of, obviously, Judge Davenport's testimony, some of the overlays that go through this would lead defense counsel to say, don't do this. And any reasonable client looking at it with a parent or a guardian ad litem would like to say, don't do this. And we'll go back to having 20 people a year in youthful offender. And I've seen, a bit frustrating over the last couple of years, that over the last 10 years, we had Justice Reinvestment 1, we had Justice Reinvestment 2, these various things that came out. Not everything that came out of those things was good, but some of the good things that came out have one by one been reversed and repealed because the folks who didn't like it when it went in to begin with are now getting traction on their issues again. And that's what I am kind of seeing with this. And so I don't support that. That's where I am at on it.
Well, go ahead, Chair.
Thank you. I appreciate the perspective. I guess, like, I'm looking at this and I get the point of that we're making changes for a very small portion of the group. That majority, this is very successful. And so I'm trying to look at this of what are changes that we can do that would address that small portion that I realize we don't have exact data and all that on it, and not impact those that are already really being successful in it. So I hear the admitting harm piece, like that seems like that's pretty clear. Like that could impact those successful people from wanting to be a part of it. But I guess I'm having a harder time understanding how these other pieces would impact somebody who's already successful in the program from not wanting to be a part of it. If they know that if they don't come to things, they're going to potentially have to be summoned like that. I feel like that's not as bad as you have to admit that you did something wrong right at the back.
Well, yeah, I mean, one issue doesn't impact the other. But there are other issues as to the appearance. And is there a problem with what the judges do now? Is there, there are some folks who don't show up. There are lots of folks who don't show up all the time in criminal court and in other courts, and family court and for child support hearings and divorce hearings and everything else. Many times and most of the time, judges, these folks have a good reason. And then there's a fair number of times where they have no good reason. But this is where judge has discretion to use the tools that are at their disposal, get that person to court, or to make sure that their lawyer, or try to get their lawyer to find them. Lawyers sometimes don't know when they aren't going to show up in court, and then they've got to figure out why. You have kids who are in marginal situations at times. Some are homeless, some are transient, some are living with people who, not family members, who don't have like a direct responsibility for them getting anywhere or being anywhere. There's issues with communication. There's issues with, you even have the same cell phone Do you have a cell phone? Are you share? One of the things we find all the time with our clients, they share cell phones. So you call the person who actually has it in their possession. They don't tell you what's happening next. They don't have a set address. All of these are like good reasons why you don't show up to court. It's not a lack of wanting to show up to court. You don't even know you have to show up to court. That having been said, at some point we figure out who they are, where they are, and we get them to court. And then there's some who are just kind of, the miscreants who are just not going to show up for anything ever. Well, those people are part of our system all over the place. It's not the majority. It's enough of a number to annoy people, absolutely. I kind of disagree with the judges on granting family court judges the right to issue an order to bring somebody to court. The court is a unified court system. Family court judges sit in criminal court. Some judges sit in all three courts. In Addison County, the one judge sits in civil, family, and criminal. What's the difference? What hat you put on? You're the judge. You want somebody there, you order them to be there. Their judge can issue all kinds. I like the ability of judges to have discretion to listen to the facts and circumstances and determine what they need to do to get this person to court. If they talk to the lawyer and the lawyer says to them, look, I know where this person is. I don't know why they happen not to be here today. Put this on for next week and I'll get them here. That's good. You shouldn't be revoking youthful offender status because of that. Let the judge exercise the discretion they need to exercise. Do we not trust the judges to make decisions that are within their discretion? I don't always like the decisions they make. Nobody does. But I would rather have them have the discretion to make decisions based on whatever facts and circumstances present than say you shall issue an arrest warrant or you shall drop the hammer, however big the hammer is, whether it's a rubber mallet or a sledgehammer. Let the judge make that decision. So I don't want, my opinion, I don't want the legislature kind of throwing the baby out with the bathwater and going directly to the sledgehammer every time. Let the judge make the decision about what's necessary. Invest the judge with that power to do what they need to do to get that person to court. I would suggest, and I see, both judges talked about, I guess, the child support situation where people don't show up. To get in a situation where you end up in contempt and you are going to be subject to an arrest warrant for child support, it's a number of times. It's not just like, oh, you didn't show up, now you're arrested. It's a number of times down the road. So we make sure this person knows they absolutely have to be there. They have something in their hand. Their lawyer has told them, somebody else has told them, and they are just refusing to come to court. Kind of thing. So don't make the decision for the judge by putting it in legislation. Give them discretion to do what they need to do to bring them to court. That's all. If one of the things I hate to see, it's not the same thing, but it's akin to, to this sort of thing. I had a client who was one of these guys who every time in November, December, when the weather started getting cold, would go out and steal something so he could make sure he could go to jail between December and April. And it was always some kind of retail theft. And the state's attorney would come in and say, well, if you plead to the felony retail theft, we'll give you a deferred sentence. We'll put you on probation. You won't have a crime on your record. And always sounds like a good deal, right? Like you would make. He'd be like, no chance. I'll plead to 4 misdemeanors and I'll take 90 days in jail. And 2 reasons. Number one, he wanted to be housed during the cold weather. But number 2 was he knew he'd violate his damn probation and his deferred would be violated and he ended up with a felony on his record. When youth are making like this analysis, if they believe, first of all, they've got to admit to a bunch of stuff that they didn't do so they can get into a program so they don't have anything, even if they did something, right? So whatever's alleged, maybe there's 10% of the 90 that they were responsible for, and 90% they weren't, but they're required to say, yeah, I did it all and it was so harmful. Well, some might just go along with it to get into the program. Also, you get the next step. What if you know that, you gotta make sure you're everywhere you're supposed to be, make all these appointments, do that stuff. Otherwise, you're revoked and you're sent back to, criminal court, or you're subject to an arrest warrant. If you're trying to do an analysis about, can I succeed the first time? Just like my client would say, can I succeed on a deferred sentence? They're going to say, I'm not going to do that. If they know that, like, look, this system is going to take into account my circumstances, my transience, my homelessness, my what I have to do to survive, and I can get to court, if I know and I'm able, that is a recognition of that client's circumstances, and they're more likely to participate. To me, it's just about making sure the judges have the tools they need so they can respond under whatever factual circumstances they're presented with. And I know they're probably to some degree conflating like the original version and then the stuff that came in last night. But conceptually, what you don't want to do is provide harsh consequences in statutes that don't take into account the full circumstances, which would deter somebody from participating in the program at any level. And that's what I see this doing for a program that's actually working.
Other questions from that? So I did have one as far as the situation where there is a motion to modify or revoke at almost 22, or, when they be. So we have a provision in here that says essentially until that motion is resolved, the jurisdiction continues. What is the downside problem with that?
The only thing that concerns me really about that is that this sort of allows the judicial system to diddle around as long as it needs to resolve the issue. And so a person enters into the program thinking they have a legitimate end date, and right before the end, not necessarily for a new crime, but for perhaps a violation of or a failure to comply with a non-criminal condition of the youthful offender agreement and order, a filing is made. And by the time we get around to it in court, the person's on youthful offender status for another 2 years. As we're, as the system, as it tends to be backed up and backlogged, what the system as it is now provides incentive for everybody to get it done before the age of 22. Now, is there sort of a nonsensical unfairness if there's something serious that had occurred before the age of 22 that we need to adjudicate? Yeah, there is, but it also provides incentive for the state and the judiciary and the defense and counsel for the youth to get the thing resolved before the age of 22. When you take away an actual deadline, there's no incentive for that, and down the road, this could go on for quite some time. There's pluses and minuses to both. And, of all of the things that I'm concerned about, that's one of the least. But there's reasons why having a deadline are legitimate. And, maybe it's one of those things where, this is one of the things where, again, I'm negotiating against myself sort of thing. But if you file something within 30 days of the termination reaching 22 years old, maybe there should be a requirement that it be adjudicated, whatever that is, needs to be adjudicated within 90 days. Or something like that. So that you can't be, jerked around for 18 months while everybody's, doing other things. And this wasn't a priority for the 2 years you were on youthful offender, but now it became a priority 30 days before you were going to age out.
So we can have if there's something pending that has to be resolved by X.
Yeah, within 9, whatever, choose a day, we have the 60-day cases in criminal court, your speedy trial type stuff. If there's something that needs to be resolved, then it's filed while it's pending for the age 22 age out, that you have to resolve it within 90 days. Choose a date that seems fair. But don't make it a year. But you know what I'm saying? Just so there's incentives, like now everybody knows, let's get on it.
Okay. Anything else for, or did you have anything further, Matt? Okay. Thank you very much for the input. Appreciate that. So we will go to Judge Zone, I believe is our last witness, which is good because we don't have that much time.
Well, I'll be quick. Tom Zone, Chief Superior Judge. I listened this morning and I think my notes are correct. Agree, policy, no, I'm sorry. There's a lot that's going on with this bill. I'm just going to hit a few topics that I think are ones that if you go forward on that I think that could be problematic. I'll pick up on the last one that Mr. Valerio was just talking about, and that is the modification, revocation when there's a motion for that, and extending it essentially. Past age 22. I don't see what happens if you're seeking to modify going past 22, because then you're going to what's the age that it goes up to? In other words, if you're going to modify something, let's say it's on the last month, you modify it. Well, if you go past 22, what's the age of YO then? Can you modify it and keep somebody on YO indefinitely? Can you add a year? There's nothing there for guidance. And so I don't know that modification should be in the same bucket as revocation.
So it should be a motion for revocation.
I think so, yes. I don't know.
Unless the plan is right, unless we, as it is right now, it could be modified and it's gonna be another 2 years or whatever for them to complete program, which is presumably that's not what we want to do, and that's certainly.
But then you're giving the judges the subjective ability to raise the age to whatever they want.
Right. So it could be just revocation.
And if it's revocation, I don't know that I agree completely with what I've heard this afternoon on that. If someone has violated a term of probation in adult court and their probation term is coming to an end, probation officer will file the violation, and that stops it, if you will. They then can address it. The court can then address it even after the expiration. And if it's and so this is very similar to that in my view. If there's a violation because someone absconds and they're not participating, and that's filed, and then they go and they're picked up and they're finally come back before the court at age 22 and a half, the court should be able to address that and decide whether or not it's going to be revoked. If it's not revoked, then by virtue of the fact that the individual has turned 22, it's over and they're deemed to have successfully completed it. But if it is revoked, it goes back to the criminal division for sentencing. Right. And so I don't think it's workable to add a time frame and say you have to address it within 90 days, because we don't know if the person's even going to be around.
Right. Understood.
So,
okay.
There was also, Representative Arsenault had asked about good cause. She's not here, but the short answer is there's no one universal definition. It depends. The answer is, unfortunately, it depends. The court for good cause would have to look at a number of factors. Is there a legitimate explanation showing diligence, reasonable conduct? And you have to look at the particular circumstances of each case, individualized assessment. It is subjective. And so I do agree with Mr. Valerio when you're looking at some of the provisions that talk about shall and the one size fits all model. That takes away from the ability of the courts and judges to be able to assess matters on an individualized basis. And that's what sentencing, that's what the system is geared towards, trying to assist people. It's a policy. If the legislature wants to say we're going to have a one size fits all model, it can certainly do that. But where the courts have the discretion and the ability to assess cases individually, that's something that, according to the data that apparently Mr. Valerio and others have talked about today, that seems to have worked in this very realm that we're talking about here today. And I do know, I think Judge Davenport mentioned about warrants and that the family judges shouldn't be issuing warrants. I must say I can't agree for a number of reasons. I think I agree with Mr. Valerio. First of all, if you're in Addison County, you're the criminal judge and the family judge. It makes no sense to say we're going to go put on a different hat. If the court, the family division is dealing with this case, I don't see a reason why the family division shouldn't be able to issue any warrants that are necessary to address the case before it. Sending it back over to the criminal division adds delay. And let's say it's not a one judge county, then it goes to another judge, then it goes from one judge to another. We don't need that. We're trying to get rid of the ping pong effect. So one judge should be able to handle the case before them. That also ties in somewhat to the discussion about what I'll call the acceptance of responsibility component at the beginning, when someone is now looking to be accepted, and the factor about acknowledging the harm was caused by the use of alleged conduct. That is a policy decision. I would note that I think Judge Davenport makes a good point when she says that, it's the judge and it's the same judge who's going to be hearing the case. I think that judges do have the ability, we do it all the time, to say, okay, yes, I know X, but I can't consider X. And we put that line up, we put that divider up, and we decide the case based on what we can. It's just like in a trial, if you have evidence that comes in and you say, I can't consider that, or you have suppressed evidence and you're the fact finder in the case, if it's a bench trial, you don't consider it. I think the other side of it, though, is even accepting that the judges can do it, how does it look to the young men and the young women who are standing before the court thinking, is that judge really going to block it out? And so I just think that we have to look at the process itself and determine whether or not the individual has a comfort level who's standing before us and believes that he or she was treated fairly through the system. And again, this is a policy decision. It appears that if the legislature goes with the policy of having the acknowledgement up front, I understand from Mr. Valerio that he thinks the numbers are going to go down. They may. I also could see a circumstance where the attorneys tell their clients, okay, I want you just to stand up, look at the judge and say, Judge, I acknowledge that if I had done what they have accused me of, that there was harm caused to the victims here. Is that sufficient to accept? And if we deem that sufficient, my question is, what do we really get out of that? And so that's a question for the legislature, for the policy. It is only one factor, so it's not the factors are to be weighed, not counted, and it's not disqualifying. So if a youth stands up and the attorney says, I'm not going to answer it, the judge still has to weigh in all the other factors, and a judge may well say, I understand why you don't want to. So again, that's a policy decision, and happy to answer any questions.
Yes, so 2 questions. So this is going on page 6 to 7, this whole piece, if the youth fails to appear at a probation revocation hearing. And I'm hearing the piece that, we're adding the shall, so that's getting rid of judicial discretion. in this version. I guess my question is, does the judiciary have the tool to use the summons right now?
We can issue summonses. We also, Title 33, Section 5108 says, if after being, subsection B, if after being summoned, cited, or otherwise notified to appear, a party fails to do so, the court may issue a warrant for the person's appearance. There's a statute that says we can issue a warrant.
So I guess I'm trying to find like what we're hearing is that there are some folks that don't show up, right? And those are the folks that we want to get to show up. So what is the barrier right now from judges using that tool? I think I get the point of let's not force the tool, but also how do we make it so that it's better used?
Well, I can't speak to whether the prosecutors in certain cases are asking the judge for a warrant. In other words, a prosecutor, there may be a situation that someone has spoken to one of the other witnesses or a member of the committee and given anecdotal information. And yet in court, the prosecutor said, Judge, we're satisfied. Let the attorney try to notify them. In other words, I don't know if it's a matter of the courts or the judges saying, I'm not going to issue a warrant. There's not enough here to issue a warrant, or if it's a matter of discretion being exercised by the court, perhaps even with the assent or request of the state to not go down a certain path. I acknowledge that there are certainly cases where individuals don't show up, and it's frustrating to the courts. It's frustrating to all involved, and we need to be able to take the steps to bring them in. But again, there are provisions that talk about issuing a warrant. If the probation officer has the ability to put that person and detain them under the statutes. So there are mechanisms to bring people in.
Okay, so that's helpful to know that the tool does exist out there. The other question I have is on the effective date. It says on passage, and I think it came up that we need to be extended like July 1st. Is that true that you would need more time, or does on passage work?
I think that a bill like this, if the legislature goes down that road, should have some time between passage and the party and letting everyone know there's going to be a change, because it will be a change that's going to impact how people decide to go forward.
Thanks.
And I think Mr. Valerio may have said this too, that there may be, I'll use the word tweaks or statutory changes that can be made to address the individuals, Representative Dolan, that you're talking about. That, okay, if we want to make it clear, if we're hearing that some judges don't think they have the authority to issue a warrant, well, maybe we can put something in to make it very clear that a warrant can be issued for X, Y, and Z. You know, there are things that could potentially be done, I'm sure, to address these issues in a way that provides clarity and gets everyone, if you will, on the same page.
Well, that's what I'm like. I don't know if it would be helpful if we just turned it to May even, but that's where I don't know if it's worth, like, you already know it's a tool, but is by putting this in here, like that's reinforcing, like, okay, you should really be considering this.
It's already in the statutes.
Yeah.
So it does seem to kind of be buried in, well, not buried, but 335108 is not in the same chapter that we're talking about. So I could see wanting to put in similar language with may, may summon juvenile to appear before or may issue a warrant for the juvenile's apprehension and transport to the court. That would kind of follow what is in 5108. So I understand why you wouldn't want temporarily suspend. But if we were to add as a second part of this after the summons and warrant, that if the individual continues to not show without good cause, that the court may revoke the youth status. Once again, a may. To give the court the discretion, but right now I don't think the court would have the discretion to revoke just for failure to show after the effort to track down the youth.
I think there's a number of other concerns that I've heard raised about that also that the courts would have to address. is failing to appear, is that really forfeiting your right? And so is there a constitutional issue there? Those are things that the court would have to address and look at if that were to happen. That says in all cases, if you do X, Y is the result.
Or we could just have the main language with the summons and warrant, and we can ask for a report in 3 years to make sure it gets in front of whatever committee is here at that point, whether that's working or not. Or we could, I don't want to sunset it, but just so we can see if, well, is this working well enough, or do we need to take, further action and do the revocation thing? That might be another thing to do. Some ideas. Anything else for Judge Zone? Okay, all right. So, oh yeah, Matt, please.
I would strongly suggest that you do it July 1st.
Yeah, we'll do that.
Because we train in June, and I have 200 lawyers present. I know the courts train in June. So if you're going to change something, much better.
Right. Yeah, definitely.
I didn't know if it was.
No, I don't think that's an
really
issue. That's not an issue. But we'll definitely do that. So we have 6 minutes, and Matthew, if you can get into a few, I apologize for not having put you on here. If you want to make a few comments on this, you're welcome to join us. And I apologize that I overlooked getting you on this list. Welcome back.
Thank you. I look a little different perhaps. So I will reintroduce myself. My name is Matthew Bernstein. I'm the Child, Youth and Family Advocate for the state of Vermont. I think most of you are not new. I recognize a lot of faces, but we do individual and systemic advocacy for children and youth served by DCF as a summary, primarily in child welfare and youth justice. And we have an annual report. So I guess, I want to say something first, which I think is not directly, germane to the four corners of this particular bill, but I think is relevant, and I'll keep it brief, which is in our annual report recently published. I have paper copies here if anybody would want one. Our office analyzes DCF's spending by using their own numbers and comparing that to other states by categories. And, the way we separate that out, and indeed, I think it's useful, is, sort of the upstream preventive down to the deep end. So the two most preventive categories are, one's called prevention, right? And then the other is child protective services. And the takeaway is that Vermont is one of the states that spends the least on those two upstream categories, but we spend virtually the most on the deepest end of the system. And so when it comes to, some of the earlier testimony about services DCF has, I think it's important that DCF be fulfilling its duty to build preventive services in the youth justice space in particular. The way our office sees it, they're investing a lot of their time, energy, and money to create secure settings or acute settings, which are needed in general. But I don't see an equal effort on the prevention side. So that's, not directly relevant to this bill, except it's a structural problem that I think if we don't start making inroads on, we'll be here in 10 years saying the same thing. Oh, we don't have preventive services. We have to deal with the day-to-day. And it's hard in state government to look long-term, but just want to make sure that that's out there. Second, in terms of the more specifics of the bill, I'll defer to the experts, who practice in this field every day. I'm an attorney. I worked primarily when I was a working attorney representing clients in child welfare. I had a lot of clients who were dual involved, but I was not their criminal defense attorney. However, from a legal layperson's perspective, and from speaking with folks, including, folks on the prosecutorial side, I just want to make sure that we are clearly understanding what the problem is here and narrowly addressing that in a way that balances the interests of, protecting the community and, and also ensuring that our youth rights are upheld. I have two children. I have a 5-year-old daughter and a 9-year-old son. And, we work, substantiation of child abuse and, ensuring that my kids are safe in their settings. And that if, God forbid, something were to befall them, that justice was achieved, is important. And I have a close friend who was, brutally assaulted by a youth in New Mexico, and was instructed to sit in the courtroom for those proceedings. So I think community safety is crucial. However, sometimes I think what happens on the youth side is that we try to. There's a sometimes unintentional, I think, frankly, a bit of paternalism here, where we sort of say these are our, and that's maybe pejorative. And I think that there's a feeling that these are youth, and so therefore it is our job to protect them, to guide them, et cetera. And that can lead to maybe trying to solve problems in the youth justice space that we don't solve in the adult space, that we don't try to solve in the adult space. What I mean is, for example, I was surprised to hear Judge Zone say that a judge has the ability to issue a warrant. And if the issue is there's a youth out there who's absconded who needs to be brought to court to face their day in court and their due process, and that tool is not being used, then that doesn't seem like this bill solves that one way or another. That sounds like a tool that already exists that judges can avail themselves of, and so, and I was talking to some of the prosecutors earlier, because in reading the youthful offender statute, just reading through it again today, it's quite complicated, but on paper, I think it appears to me like prosecutors have a lot of tools they can use when a youth is not coming to court. And so if the main issue here is that youth don't show up to court, and therefore, and a judge or a prosecutor is hesitant to take punitive actions based on that, then I think that should be the narrow scope of this problem. But we don't, I still just have trouble understanding the real big issue we're trying to solve here, because as somebody said hours ago, you're making a system that does the best it can, and sometimes there are, you're not going to catch every scenario. But what I worry is that this bill tries to kind of do too much to solve a problem that I'm not sure how big the problem is, and I don't, and I have not been. We've had a lot going on, so I've not been following this bill as closely as I wanted to. But I'm not totally clear on the scope of whether this bill really remedies, what it seeks to, and I'm concerned that maybe it brings in other issues, as others have said. And then just lastly, I'll say I think that piece of I completely understand, from a victim's perspective or from somebody impacted by a crime or the actions of a youth, why wanting somebody to be accountable, to apologize, to face what they've done, is something that folks want. And I completely understand that. I'm not sure that this bill is the place to try to address that. And it is a very hard problem, right? Restorative justice is an important field, a tricky one. And my friend, the thing she wanted was for her attacker to go to jail for a long time. And that's ultimately what happened. Sometimes that's justice. But I think when you're closer to the line of a, crime or alleged crime, that's much more like, a youthful type of crime that verges, because I think we're not talking about the most serious offenses here, right? I don't think we're talking about, the next couple of levels down. I think, sexual assault was mentioned. That's obviously something that's very serious. But I'm not sure that putting into statute that a youth should verbally account for that is within the ability of this bill to solve. And I worry about, all of the other problems that creates. So, I appreciate your time and here for questions. And I'd love to hand out my annual report to whoever would take it.
Great. No, I'd love to.
So
Great.
we're always,
When did that report close?
we finished it about a month ago.
Okay, so yeah, so I haven't seen that, but
We are doing our best. We have 2 people. So we've been overwhelmed.
I do recall looking at.
Should have been out earlier.
No, that's absolutely fine. It's just, I'm pretty sure I looked at the most recent annual report and didn't see anything really in our jurisdiction. In that.
Oh, okay.
I remembered, right?
So no, I think we're talking about the same one, but we can talk.
A new one. Okay, thank you very much.
Thank you.
So before we break, I don't know if I get a sense of where we are with this. But I'll tell you kind of where I am and if this comports with where you all are. I think there's too many problems with the youth acknowledgement of harm part that we should strike that. I'm hearing too much. I think we should, on page 5, just revocation. I agree, that's what we're after. I kind of thought it was one motion of modification or revocation. But I would imagine that would be fine. And then I heard just a slight change to the new criteria that we have. And then changing the last bit to be may and putting the warrant language consistent with 33 VSC 5108, just to make very clear that the warrant can be issued to pick up the child. And I don't know that we need a report. That might be too complicated to figure out exactly what the report is, and just count on the advocates, the state's attorneys and DPS and others to be tracking if this is actually helping us solve the problem of no-shows. That's kind of where I'm. Any objections?
Date.
And the effective date. I mean, we'll run it by the rest of
Yeah, I mean,
everybody too, but